The concept of the burden of proof stands as a cornerstone of legal theory and practice. It determines which party in a dispute carries the responsibility to prove a fact or claim, shaping the entire structure of judicial proceedings. Without this principle, courts would be unable to distinguish between competing assertions, and the balance of justice would be jeopardized. Far beyond its procedural character, the burden of proof reflects deeper philosophical concerns about fairness, truth, and the protection of individual rights against state power. This essay explores the historical roots, theoretical foundations, types, applications, and contemporary debates surrounding the burden of proof, showing how it functions not only in law, but also in philosophy, science, and public discourse. Historical roots. The origins of the burden of proof can be traced to Roman law, where the famous maxim "E incumbit probatio quaedicit non qui negat," the burden of proof lies upon him who affirms, not on him who denies, encapsulated the principle that accusers, not the accused, must present evidence. This idea was carried into medieval canon law and later into common law traditions. In the English legal system, especially after the development of trial by jury, the allocation of proof burdens became increasingly important to ensure fairness. During the Enlightenment, legal philosophers such as Cesare Beccaria and Montesquieu emphasized the principle of presumption of innocence, reinforcing that the state must prove guilt rather than forcing individuals to prove innocence. This became codified in modern constitutions and human rights conventions, such as Article 11 of the Universal Declaration of Human Rights, 1948, and Article 6 of the European Convention on Human Rights, 1950. At its core, the burden of proof embodies the tension between two values. One, justice and fairness, ensuring that individuals are not wrongly convicted or disadvantaged. Two, truth-seeking, ensuring that courts and institutions reach decisions grounded in evidence. In criminal law, the balance tips toward protecting the individual, since wrongful conviction is considered more harmful than wrongful acquittal. In civil law, the balance is different, as disputes between private parties often concern compensation, contracts, or rights where the harm of misallocation is shared. The philosopher John Stuart Mill supported the high standard of proof in criminal cases by arguing that liberty must be safeguarded against unjust state interference. Similarly, Blackstone's famous maxim, "It is better that 10 guilty persons escape than that one innocent suffer," encapsulates the ethical foundation for placing the burden of proof heavily on the prosecution. Types of burden of proof. The burden of proof is not a single static concept. Rather, it has multiple layers. 1. Legal burden, persuasive burden. This refers to the obligation of a party to prove its case to the required standard. For example, in criminal trials, the prosecution bears the legal burden to prove guilt beyond reasonable doubt. 2. Evidential burden. This refers to the duty of a party to produce sufficient evidence on a specific issue to make it worthy of consideration. For instance, in self-defense cases, once the defendant raises evidence suggesting self-defense, the prosecution must then disprove it. Term 3. Tactical burden. This is a practical responsibility rather than a strict legal one. It reflects strategic necessity of presenting evidence to avoid losing a case. Even if not legally required, a party might take on the tactical burden to strengthen credibility. Standards of proof. The burden of proof is closely tied to the standard of proof, which determines the degree of certainty required. Beyond reasonable doubt, the standard in criminal cases requiring a very high level of certainty. Balance of probabilities, the standard in civil cases, meaning that a claim is more likely than not. Clear and convincing evidence, used in some legal systems for cases like fraud, where the consequences are serious but not criminal. The differences in these standards illustrate how law seeks to balance accuracy, efficiency, and fairness. Application in criminal law. In criminal law, the burden of proof overwhelmingly rests with the prosecution. This reflects the presumption of innocence and protects individuals from wrongful punishment. However, there are exceptions. For example, in certain statutory offenses, like possession of controlled substances, the burden may shift to the defendant to prove lack of knowledge or lawful authority. These reverse burdens are controversial because they appear to weaken the presumption of innocence. Courts, especially under human rights frameworks, often scrutinize such laws to ensure they are proportionate and justified by pressing social concerns, such as public safety. Civil cases operate under a more flexible burden of proof system. The general rule is that he who asserts must prove. For example, in a contract dispute, a claimant must prove that a valid contract existed and was breached, while the defendant may need to prove defenses like duress or misrepresentation. The balance of probability standard makes civil litigation more accessible and efficient, but it also means that cases can be decided on relatively slim margins of evidence. In philosophy and logic, in debates, the burden of proof falls on the person making a claim. If someone asserts the existence of a phenomenon, they must provide evidence rather than demanding that skeptics disprove it. This principle underpins rational discourse and scientific inquiry. In science, the burden of proof lies with those proposing new hypotheses. For instance, extraordinary claims, like the existence of new particles or paranormal phenomena, demand extraordinary evidence. Karl Popper's philosophy of falsifiability emphasizes that scientific claims must be testable and open to disproof. In public discourse and politics, the burden of proof often becomes blurred in politics and media. Disinformation campaigns may shift the burden onto opponents, forcing them to disprove false claims. This manipulation undermines rational discussion and highlights why critical thinking and media literacy are essential. Contemporary challenges. 1. Terrorism and national security. In some jurisdictions, laws have shifted burdens in cases related to terrorism financing or possession of explosives. This raises debates about whether security justifies limiting the presumption of innocence. 2. Discrimination cases. In employment and discrimination law, once a claimant shows a prima facie case of discrimination, the burden shifts to the employer to justify their actions. This reflects the difficulty individuals face in proving internal motivations of organizations. 3. Artificial intelligence and algorithms. As AI is increasingly used in courts, insurance, and policing, questions arise about how the burden of proof applies when decisions are based on opaque algorithms. Who bears the burden to prove that an algorithm is fair, accurate, and non-discriminatory? 4. Public health and climate change governments often argue that industries bear the burden of proving their products or activities, e.g. tobacco, pharmaceuticals, fossil fuels, are safe. Shifting the burden in this way reflects a precautionary approach to global risks. The burden of proof, though procedural in nature, is deeply connected to principles of justice, human rights, and rational inquiry. From Roman law to modern courts, from philosophy to science, it has evolved as a guiding rule for determining truth and fairness in human disputes. In criminal law, it safeguards liberty by ensuring that no one is punished without strong evidence. In civil law, it structures disputes between private parties. Beyond law, it anchors scientific inquiry, rational debate, and even policymaking. Yet, as society faces new challenges, from terrorism to artificial intelligence, the burden of proof is increasingly contested. Should it always rest with the accuser, or can it be shifted to protect broader social interests? The answer depends on balancing fairness, security, and justice. Ultimately, the burden of proof is not just a technicality, it is the lifeblood of justice and truth. Societies that respect it remain committed to reason, fairness, and the dignity of individuals. Sources: Beccaria C., 1764, on Crimes and Punishments. Blackstone W., 1765 to 1769, Commentaries on the Laws of England. Popper K., 1959, The Logic of Scientific Discovery. Ashworth A. and Redmayne M., 2010, The Criminal Process, Oxford University Press. Tarufo M., 2003, Rethinking the Standards of Proof, American Journal of Comparative Law, 51-3. Roberts P. and Zuckerman A., 2010, Criminal Evidence, Oxford University Press. European Court of Human Rights, 1950. Convention for the Protection of Human Rights and Fundamental Freedoms.